Good afternoon, everyone. Welcome to the Appellate Division First Department. I'm sure you already know what I am going to say, but I will repeat it. So this paper says there are over 5 hours of argument time requested. So we know that is not going to happen, okay? So, as I always say, please request the time that you believe that you need for purposes of the argument. Keep in mind, one, that we have read your briefs, we've read the papers, we are fully familiar with your arguments. Keep in mind also, this is not a perfect world, okay? We don't live in a perfect world, so you're not going to get the time that you would actually need in a perfect world. We are in the Appellate Division First Department, semi-perfect world, okay? People versus Ronnie Lacey. Excellent, very good. That's a great start. Powell versus the City of New York.
Appellant 5 and 2, please.
5, 2, and 5. Sanchez versus MC 19 East Houston. Is there a respondent? Did you wish to submit, or did you still wish to argue? Well, I have a preference, but you know. Okay, 2 minutes, thank you. Brunette versus JP Morgan Chase. 5, 4, and 1? No, I'm sorry, 4 and 1. Okay.
Respondent JP Morgan Chase, 5 minutes. Respondent DBSI, 1 minute.
I may even give you 2. Because by the time you get up here and I put the light on, your time is up. MRE Technology versus Smith's Detection.
Good afternoon, Your Honor. Appellant 4 and 1.
Ma versus 40-44 West 120th Street. There's no respondent, so submitted. First respondent, 2 minutes for the appellant. Angelo Gordon, Real Estate versus Ben Lab Realty. 525. Gemsco Realty versus N47 Associates.
Good afternoon, Your Honor. Appellant cross-respondent respectfully request a hearing.
Respondent request roughly 10 minutes.
626. People versus Angelo Rodriguez. 525. People versus Gustavo Holgan. Submitted. Parker v. Parker.
Good afternoon, Your Honor. Michael Love for the appellant.
8, 4, and 2.
10 and 5.
Hike. I mean, I don't know what you're doing. Yes. 525. Knight versus New York Presbyterian is submitted. Manhattan Telecom versus Coordinated Behavioral is submitted. 180 Life Sciences versus Tice Capital submitted. All kidding aside, obviously, if we have additional questions, we will go beyond the time, okay? First case for argument is People versus Ronnie Lacey. Whenever you're ready.
Good afternoon, and may it please the court. Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Ronnie Lacey. This case is governed by People v. Hardware. The rule laid out in Hardware is simple. An indictment for persistent sexual abuse must specify which of the 3 potential qualifying offenses the defendant is alleged to have committed. Mr. Lacey's indictment fails that test. His conviction must therefore be reversed and the indictment dismissed. In hardware, as here, the indictment alleged the defendant subjected another person to sexual contact. This court held the indictment was jurisdictionally defective and that it did not charge the defendant with the commission of a particular crime. The court observed that the bare allegation of sexual contact was insufficient because, quote, sexual contact is an element of all three qualifying offenses. The only additional allegation in this case as compared to hardware is that the contact was without consent. But absence of consent, like sexual contact, is an element of all three qualifying offenses. For the same reason, it fails to distinguish between them and fails to clarify which specific, discrete qualifying offense Mr. Lacey is alleged to have committed.
So the people argue that the additional language without consent tracks the statutory definition of sexual abuse in the third degree and therefore adequately specifies that underlying offense.
Yes, Your Honor. I guess the first thing I'd say to that is I don't think it's possible to square that argument with the rationale of hardware for the reasons we lay out in our brief. Hardware is pretty clear that the fact that an element is common to all three offenses is a problem if you're trying to distinguish which of them they are. And again, both sexual contact and absence of consent are elements common to all three qualifying offenses. The other thing I would say is that all of these cases that talk about tracking the statutory language, going back to, I think, Iannone, which is sort of the seminal case on this issue, say that that's the general rule. And we have no objection to that in the mine run of cases. Generally, tracking the statutory language is perfectly adequate. But Iannone and other cases say that that's not true if that would still leave it ambiguous as to which offense the defendant is alleged to have committed. And that's exactly the case here for the same reasons that this court found to be a problem in hardware. I'll just quickly note here that, respondent hasn't asked you to overrule hardware. They haven't made any attempt to show that any of the stare decisis factors that would justify overruling such a recent decision are met. And so we don't see any reason to stray from it here. Mostly they just advance arguments that are either incompatible with or were expressly rejected in People v. Hardware. There's no real reason for this court to revisit issues it already touched on so recently. And so for those reasons and the others in our briefs, unless the court has any further questions, we'd ask you to reverse and dismiss the indictment.
Thank you. Yes, counsel?
May it please the court. Good afternoon, Your Honors. Christian Rose for the people. This court should affirm defendant's conviction.
And ignore hardware, right?
No, Your Honor.
Because I would think that in order to affirm the conviction, we would have to ignore hardware because hardware appears to be on all fours in terms of precedent in this type of a case.
Unless you're asking us to overrule hardware, a decision that's a year and a half old.
So to answer those questions in turn, first, we are not asking that you overrule hardware. Affirming here is perfectly consistent with hardware, which required that an indictment for persistent sexual abuse specify the qualifying crime, and that's precisely what this indictment did by alleging.
It could be, but the two factors that are listed in this indictment could qualify it for any of the three underlying offenses, right?
It's true that sexual contact and lack of consent are shared elements among all three offenses, but they're the complete elements of only one offense, and that's what's important here. Moreover, the statutory definition of third-degree sexual abuse does not remotely resemble the statutory definitions of second-degree sexual abuse, which is focused on the victim's characteristics, and forcible touching, which obviously is a very complex statute with its own very unique elements. And so it's true in our brief that we say that if we had presented these same arguments to this court in hardware, we think that the court should have ruled differently in hardware. This court can affirm in this case following hardware because we specified that third-degree sexual abuse was the underlying offense.
So in hardware, we stated that you had to specify which of the three discrete qualifying offenses defendant was alleged to have committed. So in this indictment, where do you specify the three discrete qualifying offenses defendant was alleged to have committed?
We specify that in the factual allegations. So in the factual allegations, we allege, which is precisely the statutory definition of third-degree sexual abuse, that the defendant subjected a victim to sexual contact without her consent. That's all we needed to allege. Now,
that constitutes three discrete qualifying offenses?
It specifies which of those 3 qualifying offenses is charged, Your Honor. I think it would be unreasonable to assume that the people somehow were going to pursue a different theory at trial based on the victim being less than 14 on these allegations, that the victim or that the defendant had degraded or abused the victim.
So when you talk about the factual allegations in the indictment, that's what you're referring to?
Yeah, the factual section of the
The
indictment.
factual section of the indictment. Is that the portion that says subjected another person known to the grand jury to sexual contact without the latter's consent?
That's right, Your Honor.
And so, for the third time, where does that constitute 3 discrete qualifying offenses defendant was alleged to have committed?
So just to make 2 quick points on that, Your Honor. The first is that if we look at the statutory definition of sexual abuse in the 3rd degree, it says specifically that a person is guilty of sexual abuse in the 3rd degree when he or she subjects another person to sexual contact without the latter's consent. The Court of Appeals has said that tracking the statutory language of the offense is sufficient to have a jurisdictionally valid indictment. And just to your other point, Your Honor, I think it bears noting that it's not clear exactly how the people should be charging this under the defendant's theory. For example, if they wanted us to include the statutory title or section number of 3rd degree sexual abuse in the factual allegations, that too could get hairy, because then you might have a duplicitous account where it's charged that they're alleging both persistent sexual abuse and a separate lesser included. I see my time is expired, Your Honor. If I
You can finish your thought.
Just that I think that could raise serious duplicity concerns, and I think that we're walking a very fine line for what exactly needs to be pleaded here, where this is a standard pleading and consistent with the CGI instructions as well.
Thank you.
Just to very briefly answer respondent's last question about how they should be charging it, I think the simplest way would be to cross-reference either the statutory title or just the section citation of whatever qualifying offense is at issue. I don't think there's any chance that would create a duplicitous count. I've never understood it to be the case that charging the elements of a lesser included offense in a greater offense somehow creates a duplicity problem, and I don't think that would be an issue. And just with respect to what respondents said about the different statutory definitions, it's true that there are different elements, which is why it matters which offense is charged. But I think that using sort of common language, subjected someone to sexual contact without consent is also a perfectly ordinary way to describe the offense of sexual touching, or forcible touching. And so that's why this factual section doesn't really distinguish, at least between 3rd degree sexual abuse and forcible touching. I'll grant that 2nd degree sexual abuse is sort of its own thing. But because there's no clarity about which of the qualifying offenses was at issue, a lack of clarity which continued into and throughout really the entire trial, this indictment was jurisdictionally defective, and we ask the court reverse and dismiss. Thank you.
Powell versus the City of New York. Whenever you're ready.
May it please the court, good afternoon, Your Honors. Christopher Della Carpini for the appellant, Mr. Powell. So let's put aside the law of summary judgment and initial burdens and all that for just a minute and get to the question at the heart of this appeal. Does an owner's nexus to permitted work extend beyond the permit to work finishing up the job? Well, we have 2 Court of Appeals decisions that suggest that in fact it does. The first of those is Morton v. State. Morton v. State, the Court of Appeals was clear. A work permit will create the nexus necessary for labor law liability. They were quite clear that if the claimant's employer had gotten a work permit—
Counsel, what about an expired permit? If a permit is expired, as it was here, and the city conducted an inspection 3 days before the expiration of the permit?
3 days after. I think they did it on the 15th and the permit expired on the 12th.
The inspection was on December 9th.
No, the accident was December 9th.
Oh, sorry.
The inspection was November 15th. The expiration date was the 12th. But you're absolutely right. That is the question, and I think that particular question is answered by the Court of Appeals in Sanitas. In Sanitas, the employee was injured installing air conditioning for a tenant on the premises. That tenant had a lease. That lease entitled the landlord to prior written notice of such work.
There was no lease here, though, right?
There was no lease here, but
Was there a contract?
there was, no, there was a permit. And as the Court of Appeals said
Okay,
in Morton,
so there's 3 distinguishing factors so far.
I don't think
No
so.
lease, no permit, no contract.
No, but as the Court of Appeals in Morton said, that's a distinction without a difference. What you need for nexus is a grant of
Morgan
property
said
interest.
some nexus between the owner and the worker is needed, such as a lease or an easement or other property interest. So where is the property interest?
The property interest is in the work permit. I would direct you to Morton, the
So,
paragraph.
counsel, you're saying an expired work permit gives you a property interest?
Your Honor,
That's,
yes.
yes?
Because of
How,
Sanitas.
it expired the week before? How about if it expired 3 years before?
That may be a question of fact. Fortunately, I don't have to
You
deal with
think
that
that
fact
that's a-
here, because
that-
here I have 3 weeks.
So that's exactly it. If it is expired, it's expired, right? Doesn't matter whether it expires 3 weeks or 3 days or 3 months or 3 years or 3 centuries.
I would submit that Sanitas suggests otherwise. In Sanitas, the work being done, as I was saying,
Where do you see that? Where does it suggest that?
as I was about to say, in Sanitas, the employer's work was actually contrary, in violation of the lease. The lease required prior written notice. The landlord never got it.
No, but there's a lease. There's an extant lease.
Whether
That's
you have a lease or
completely
you have a
different.
work permit, what you have
If you
is a
had
grant
a-
of property
See,
interest.
here's
let
the,
me just
here's the,
interrupt
here's the
you
thing.
one second.
You really have to allow the justice to complete her question to you before you can answer.
So if you have an expired lease, there's no, in that case, there was a lease in force. If you came to the court and said, under this lease that expired a month ago, there is a property interest, I think that is a different case. That's what you're saying here, which doesn't even rise to the level of a lease. It's a work permit, and it expired. And there's no connection there, the same way there would not be a connection with an expired lease or something that used to be but isn't now.
May I answer the question?
Yes, of course.
There is no difference for our purposes between a lease and a work permit. As the Court of Appeals said in Morton, what you need is a grant of a property interest, and the court said in Morton unambiguously, a work permit provides nexus.
A current work permit, correct? Not an expired work permit, not an expired lease, not an old lease, a current one, correct?
I didn't see current work permit in
Have
Morton,
you
Your
seen
Honor.
any case where any court has said an expired lease, an old permit, something that wasn't current actually gave the nexus?
Your Honor, as of about 10 o'clock this morning, I see no cases in this state dealing with an expired permit either way.
Or an expired lease or any expired old connection.
Absolutely
that
not.
isn't
What I
current.
do see is Sanitas, where work that was actually in violation of the lease. I don't know, our work was at least in furtherance of the permit. This was finishing the job.
Counsel, would it be correct to say that the franchise agreement explicitly required additional authorization to occupy the affected area? I mean, a permit is nothing more than a temporary license, right? To achieve a designated purpose.
Your Honor, a permit may or may not be temporary. This one certainly expired on November 12, 2017.
Oh, it was a temporary permit.
This one expired on that point. What we are saying is that even in contrary to the interest that creates nexus does not define it.
You're saying, so what?
Not, in this case, certainly, because we are finishing work. If Sanitas is still good law in this state, then this is certainly within the ambit of the nexus that the state unambiguously had up until November 12th. Nexus did not evaporate at midnight on November 13th.
Thank you.
Thank you.
Hi, good afternoon, judges. My name's Janet Ford from Fabiani, Cohen and Hall.
So, counsel, let me ask you, what do you say to that argument that you can create a nexus by an old lease, something that's expired, something that isn't extant anymore, that doesn't currently give the two parties a connection to each other?
Judge, I think that's a preposterous argument. I think the permit expired. 3 days later, the city of New York went there to inspect the place where Verizon was supposed to work and found there was no work done. And then, about 3 weeks later,
And may I ask you, is there anything in the record that disputes that inspection?
no evidence whatsoever. And
I just, okay. No, I'm done.
Counsel, I have a different question. The complaint in this case alleges a cause of action under the labor law.
Correct.
Your motion for summary judgment does not address the labor law at all. And there's an opposition, and in reply, you address the labor law. Why isn't your failure to address the labor law and failure to create a prima facie case for summary judgment?
Judge, we might have argued the wrong law at the outset, but we sure set forth the correct facts.
How were your facts adequate to establish that you were not liable under the labor law?
Well, the facts showed that there was no permit, no nexus. The facts established no nexus. And although we might have addressed the wrong law in the beginning,
Well, not in the beginning, in your motion papers.
in the motion papers.
Right.
Although we addressed the nexus argument in the reply papers.
Right, but in your motion papers, how did you establish a prima facie case for summary judgment when you didn't address the substantive law under which plaintiff was proceeding?
Well,
I've never seen a motion for summary judgment prevail when it addressed a cause of action that the plaintiff didn't assert and failed to address the cause of action which was the basis of the complaint. Do you have any support for that? Any other cases where the summary judgment is sustained where you don't even address the cause of action asserted by plaintiff?
Yes, Your Honor. In fact, the cases on page 15 through 17 are all cases where perhaps the legal argument was not raised, but the right facts were raised so that the court could determine the case on an alternative basis. In fact, this court has found on alternative legal theories that were sometimes never raised in the court below. And I think that, the case law that I should turn your attention to on page 16 states that courts have discretion to consider movements' arguments, although first raised in reply, where they involve questions of law that could be resolved on the existing record. And I think the key principle is, was any party prejudiced? Recall that plaintiff raised the nexus argument in opposition.
So, counsel, I think the question is, or the concern, which I also share, is that opposing counsel is not supposed to be surprised by the content of the reply.
Correct.
New information, new theories of law, not supposed to be introduced in the reply. And we have tossed appeals before on those grounds. Why would this be any different?
Because plaintiff was not surprised, Judge. Plaintiff raised the nexus argument, and plaintiff had the right facts. And then we replied to the arguments raised in opposition. The reply was just what a reply is supposed to be, a response to the opposition. So we do not see where plaintiff was surprised by the nexus argument.
So, counsel, you're stating your argument is that by your responding that the city had no contract for or awareness of involvement in the work Verizon was performing at the time plaintiff was injured, and that Verizon did not have a valid permit for the work it was performing when plaintiff was injured. Your argument is that that was sufficient to show that there was no nexus, and therefore in response to the motion, in support of your motion?
Correct, Your Honor. Those were the facts presented at the outset. If not the nexus argument, those facts were presented, the same facts that supported the lower court's decision on the nexus argument.
Thank you.
Your Honor, we are all familiar with the record, and we all know that the city's motion papers don't even mention the labor law. They do not mention nexus. They offer absolutely no evidence.
Why isn't that sufficient, though? They stated there's no contract. They were unaware of any involvement Verizon was performing at the time plaintiff was injured. They argued that Verizon did not have a valid permit, which we know that the permit had expired at the time that plaintiff was injured. Why is that not sufficient? I mean, I understand they didn't put, therefore we're not liable under the labor law, but why would that not be sufficient in terms of laying out the facts as to lack of liability on their part?
Because they didn't argue the significance of those facts. They simply put a bunch of facts in there and left it to us to guess what they were talking about. In fact, you could say they misled us by citing nothing but the pothole law.
Isn't even a guess that they're therefore saying there's no nexus? I mean, as attorneys, as lawyers, individuals who know the law, would it be a guess? I mean, maybe for a layperson, but I mean, in terms, and we're talking about the motion court, right? So in terms of the motion court, would it be a leap on the part of the motion court to make that determination that this shows that they're arguing that there was no nexus?
Your Honor, the law the court below was certainly in error. It is settled law in this state. If the motion papers do not prima facie prove non-liability, the motion should be denied without even looking at the opposition papers, much less letting the opposition papers open a door for the defendants to save their argument and reply. You should not reward the city for misunderstanding this case. There are no further questions. Thank you very much.
Thank you. Sanchez versus MC 19 East Houston.
Good afternoon, Your Honors. Thank you for humoring me. Just briefly, I think there's enough evidence here to show that the ladder was secured, that it could not have moved as plaintiff.
I'm sorry, which party do you represent?
Oh, I'm sorry, the appellants. That was a good question.
You didn't make your appearance.
Yes. C. Briggs Johnson for the appellants. Sorry, I was very excited. So there is evidence here from the project manager establishing that the ladder could not have moved the way plaintiff said. Yes, Judge Gesmer?
What evidence is there that it could not have moved as the...
Yeah, so I will direct you to the record. Mr. Brooks testified that all the ladders were used to move between the floors, including the ladder that plaintiff used on the day of the
Mr. Brooks didn't specify between the two ladders that were in the basement, and he didn't identify that one particular ladder was, any particular ladder was a source of the accident.
I testified that he used the ladder that plaintiff fell from.
Yes, but which one?
The one that he used from the basement to the
No, there were
top.
two ladders.
Right, but he said that he used all the ladders on the project as the project manager, and that they have never moved the way plaintiff testified.
So because they didn't move when he did it, that means as a matter of law, they can't move?
I'm saying that as the non-movement on summary judgment, I'm entitled to the benefit of every favorable inference of the evidence, right?
That's
That
really
the fact
favorable.
that he went up and down at the ladder means that that you've raised an issue of fact that the
Plaintiff had used this ladder 50 times previously, and he said that it never moved.
Right, and then it did.
And then it did,
But
right.
there's nothing that rebuts his statement that it did move on that occasion.
Right, but he's the accident's only witness.
But that doesn't...
No,
but as
he
a matter of-
wasn't. There were two other people. I'm sorry.
Go ahead,
Oh.
go ahead.
Mr. Augustine Gonzalez and a person identified as Bernabe. That's at record 90.
Your Honor, I don't know who you're talking about. The plaintiff is the only witness to this accident, and he's the only one in the record to testify as to the facts of this accident.
He's the only person who testified, but
Right.
he identified two other people who saw the accident.
But they did not give any affidavit or testimony in this case. So he is the only witness for the purposes of the record on appeal.
Right, and is his testimony that at the time he was going up and down, is his testimony that the ladder moved, is that disputed by anybody who saw the accident?
That is not disputed by anybody who saw the accident.
So that testimony is unrefuted.
Yes, but I will say that plaintiff and Mr. Brooks both authenticated photos that you have seen in the record on appeal. I would say 230 to 231, 250 to 251, 270 to 271, that the ladder was nailed to the ground and that it was secured to the upper floor, that the ladder could not have moved.
Did anybody identify that ladder as the particular ladder on the date of the accident? I didn't see that.
I believe plaintiff and Mr. Brooks both testified that, because Mr. Brooks testified, I want to say, on 230 to 231.
No. He testified that if the ladder was secured
Right.
at 221, that's how they would be secured. He never testified that the ladder that plaintiff went up and down on
I'm sorry. He authenticated the photo of the ladder as depicted on the date of the accident. And plaintiff authenticated that photo too, but plaintiff says that magically that the nails were gone, even though for the entire project.
I don't think we have to assume that there was any magic going on. It slipped because of the structure of the ladder. I think that the use of magically is a little bit condescending.
Thank you so much. Have a wonderful day.
You too. Thank you.
Let's see, we're Burnett versus J.P. Morgan Chase.
Good afternoon, Your Honors. Jillian Rosen for the Plaintiff Appellant. In this case, 200 and 241-6 should not have been dismissed. The independent contractor argument, there are two exceptions, as we know. One of them is the non-delegable duty exception. Here, this premises was open to the public. Chase had a non-delegable duty to maintain a reasonable, safe ingress and egress. And the defendant actually doesn't even address that in their motion for summary judgment meaningfully. He just says, I'm not responsible for this area because I contracted with Paris Maintenance and they're an independent contractor.
But isn't there a prior issue, which is any evidence that clearly ties Paris and therefore City and therefore Chase to the circumstances that seem to have caused the accident?
Yes, and I think that's the second exception, I think, is really relevant here, and that would be the duty that Chase has over Paris. And if you look at the master service agreement, that is at 763 of the record, I'm sorry, 663 of the record. If you look starting at 702, it is clear that this was not just simply general supervisory over Paris, that Chase actually dictated the work.
We know that Paris was responsible for the icy condition on the sidewalk.
Well, we don't know 100% that they are, but
Do we know even 10% that they were?
we
We have Ramosco, I
Right.
think, who allegedly tells the plaintiff that he saw someone throwing a bucket of water onto the street, onto the sidewalk, and we know that it's sub-zero temperature.
right. And
Do we know, first of all, do we have any corroboration from Ramosco? Do we have an affidavit?
no,
No. So do we know that the person who threw the water was a Paris employee?
we don't, they can't rely on that, but as you know, under Rosa, your case Rosa, in opposition, I can rely on hearsay. So a question of fact is raised as to whether the janitor that actually plaintiff did see inside the front door of the bank that was mopping and had a bucket, there is a question of fact as to how this occurred, and it's not my burden, it's their burden. So what they should have done in support of summary judgment was says, not only am I not responsible for Paris, which they are under this contract, and I would like to point to 718 of the record, which really, I think, shows why they're responsible, not only for Paris, but obviously they have a non-delegable duty for the sidewalk, but they didn't come forward to say, well, this is the last time we inspected or maintained the sidewalk, this is what we do, this is how it looked the last time we did it. So even though they can't rely on that, we could certainly rely on Ramosco, what Ramosco said, in opposition to summary judgment.
But what about they don't have a duty? They're not responsible for the sidewalk.
Chase is. If you look at 718 of the record, and I think this really shows it, it says here at 718 of the record that Paris, and again, I'm saying, if
No,
you,
the sidewalk, let's talk about in this area in Warwick, New York.
yeah,
Is there any statutory duty that would require the building owner to maintain the sidewalk?
yes, I think 718 says it. I understand that outside of New York City, municipality is responsible, but look at 718 of the record. It says, Paris is responsible to sweep and remove debris from the exterior concrete areas and steps within 20 feet of all entrances and exits. He fell one step out of the bank.
No. That doesn't inure to your benefit. That has nothing to do with you. You're not a third-party beneficiary of that. The municipality has the obligation, right? So the only way that you could get around it is through Espinal, which is they caused or created it. And there's no evidence here, anything except someone said, I saw a guy throw a bucket of water, but that is not, are you saying that's your evidence?
No, in addition to what the contract has, showing that Chase is responsible for Paris, and Paris is responsible for the first 20 feet, in addition to the non-delegable duty exception, that even if it's a public sidewalk, it's a place of public assembly. And under, Backill against Citibank and all those cases which you know about, they have a non-delegable duty that they cannot delegate to a independent contractor.
But that just means that essentially all that you've just said was this company, their agent caused and created it. And I'm asking you, what evidence do you have to support that? Because you can say it however you want to say it, but that's your argument, and that's where I'm asking you, what's the evidence?
The master service agreement is the evidence.
That they caused, that this maintenance worker caused and created the ice on the
Not that it did, that there's a question of fact as to what
okay, well, that's what I'm saying.
Yeah.
What evidence did you put in that would even raise an issue of fact?
Well, the master agreement, if you look at 702 in the record, and you look at...
That only talks about its duty. I'm asking you to tell me, how do you come to the conclusion that Paris caused or created
So we're
the
back
ice?
to the hearsay you claim that you can rely on, that Ramasco told the plaintiff that he saw someone throw a bucket of water onto the sidewalk in sub-zero temperature, and that this individual worked for Paris, which I'm not sure that that's what was stated.
Well, we know that Paris had a nightly duty under the contract. Again, if you look at 718 and all the pages within what I said...
So again, how do we know that the individual who allegedly threw this bucket of water worked for Paris?
Well, I think these questions and this burden isn't on me. I think it's on the defendant who moved for summary judgment.
Counsel,
and didn't
the
establish anything.
shifting burden of proof came towards you.
Right.
And an affidavit could have clarified a lot of the questions here and provided a nexus. So we don't have, for example, I saw the worker coming out of the bank, and we have hearsay.
Let's hear from Chase.
Okay.
Thank you.
Sure. Thank you.
May it please the court. Nicholas Calabria for Chase. We move for summary judgment because in this case, the plaintiff fell on a public sidewalk, and under Labor Law 200, Chase did not create any condition, or they were not on notice of any condition.
But they are alleging that it was your maintenance company that created the condition that caused the plaintiff to fall. Now, outside of anyone from plaintiff's company at the site, who else would have been there other than your maintenance company?
I don't know. The bank was closed. The plaintiff was there with his coworker. They came up with this story that someone threw a bucket of water on the street, on a public sidewalk, and that's what caused the accident. They said it was Paris.
Could it have been possible that the ice was there, the municipality just didn't clean up the ice on the sidewalk for days or weeks or whatever?
Of course. But
Is there
and it
any
was also
evidence
something-
any
this-
way
This also
to show?
occurred at 11 o'clock at night. The bank had been closed from Saturday. This occurred at 11 o'clock at night. There was no one from Chase was present at the bank.
What do
for-
you
for a
say
day
to
and
the
a half.
move-ins argument that because you have a cleaning contract with your cleaner, that they are, I guess, a third-party beneficiary of that contract, and therefore they are entitled to rely on the fact that you didn't clean up this alleged ice?
Again, if they're saying that I still wouldn't have had notice of it. We weren't there, and this contract was just to clean the bank. The contract that I'm referring to covered multiple Chase locations that had nothing to do with this particular
So under
premises. We have no
Espinal-
idea if Paris was cleaning that sidewalk at all. This is
But
just-
your adversary stated that the contract provided for Paris to clean the exterior as well, within a certain distance of the front door.
Yeah, but it had nothing to do with public sidewalks.
But if the contract required, if you entered into a contract with Paris, which it appears you did, that required them to clear the public sidewalk, weren't you undertaking a duty with regard to that sidewalk?
I've been involved with this case since 2015, and until the reply came in, there was no mention of snow and ice ever in this case.
Well,
Now, there was, he
that's
said
not
there was
clear
a
to
little
us from the
spot of ice.
Is that in the record, that there was no prior mention of snow and ice?
Yeah, there was never mention at all. We
But
asked
if
the
you
plaintiff, the
answer my
weather, the only
question-
thing about the weather
Would
was
you answer
cold.
my question?
Sure.
My question was, if you entered into a contract that required Paris to clean up snow and ice on the public sidewalk, weren't you undertaking a duty with regard to that?
I don't think so, and I don't know.
Under Espinal, right, you would have had to have caused or created or exacerbated, right, or those type of issues, right? This is like anybody who cleans snow or who has a contract to do something on a public street or there's no, or maybe, my question to you is there any evidence that you created this?
No, we weren't even there.
And what do you say about the testimony that the plaintiff points to, that one of the guys said that he heard from somebody else, that somebody threw a...
I mean, it's a sword and a shield. They want to use it for both ways. I mean, first of all, there's only a hearsay that somebody else said, that somebody else saw. I mean, it's like, how far are we going with this? This is a public sidewalk, had nothing to do with the construction project. The municipality was in charge of the public sidewalk, and we did not undertake in a contract that covered multiple locations just because they had to clear the entrance. That doesn't mean we were doing it on public sidewalks. There's not
I
in
have
the
one more
contract.
question.
Sure.
So if in fact, you keep saying that Chase wasn't there then, but if you hired Paris, who was there then that could mean that they could have done something on your behest which caused the ice to be created. But in that case, it would have made sense to put in an affidavit by somebody saying, we didn't hire Paris to be there at 11 o'clock at night, but there was no such affidavit, right?
Right, they just worked, we knew that they worked after hours at the bank. That was all.
So they could have been working at that time.
And anybody could have been. I don't understand the case. There was, again, it's not a snow and ice case. There was no issue of them removing things. There's this hearsay allegation that somehow imbued to Chase that had nothing. It was an independent contractor. We were not controlling them. They're not our employee. We're responsible for them.
But didn't the contract provide a fairly large number of details with regard to control over their work?
I don't know if it's not control. This is what we want you to do but that's not control. We're not supervising them.
Counsel, I'm not sure how you say you didn't know it was a snow and ice case. I thought plaintiff testified that he fell. After he fell, he saw a big patch of ice about 2.5 feet by 3 feet on the sidewalk.
And he said there was no ice anywhere else on the sidewalk. So it's not like there's we're dealing with an ice condition where somebody should have been out scraping and putting salt. That wasn't what he said.
No, but you made it sound like all of a sudden.
And the snow issue, there was no
And
mention
he
of snow ever.
testified that he slipped on a.
Oh, definitely. There's no doubt that he said he fell on that piece of
Okay.
ice. It's just that we're not talking about a snow and ice condition that existed and someone didn't scrape and plow. He entered that same doorway that day, and so did his coworker.
Okay, thank you.
Thank you.
DBSI?
Put in a brief.
Good afternoon, Your Honors.
Did you put in a brief on the appeal?
I'm sorry?
Did you put in a brief on the appeal?
Yes, plaintiff appellant pretty much conceded my point in as much as in the underlying motion for summary judgment, as I indicated in my brief, they submitted no opposition. So based upon Section 5511 of the CPLR, the appeal should be dismissed, also with respect to the cases that I've cited to support that. So I think I am under a minute, so I have nothing more to add.
So, counsel, just a question.
Sure.
DBSI was contracted to do the design, the architectural plans, and the construction of this expansion of or reconfiguration of the bank in order to create an ATM section, right?
Yes, they did have, that was pretty much, that was the overall responsibility. They had a contract with Chase for, several banks throughout the country.
Did DBSI have anything to do with maintenance or cleaning or contracting persons?
None whatsoever, Your Honor.
Thank you.
Thank you very much.
Thank you.
I only have a minute, but just to reiterate, I think, under Sangare, you could have a shared responsibility as, a public.
Counsel, there was discovery here, right? There were depositions here?
Yes, sure.
Okay. So Mr. Christopher McDonald testified that he was the VP for retail banking at Chase, and that Chase contracted with Paris to work several nights a week at the bank.
That's right.
Did anybody subpoena records to determine whether Paris was even working that night?
Not that I'm aware of, but I can tell you that they produced a witness who had no knowledge of anything, and he admittedly knew nothing. So I know that the attorney requested a deposition of someone from Chase with knowledge. I'm not sure if that ever happened, but there wasn't a discussion about whether someone was there that night from Paris. But what we do know from the master service—
You want us to assume that there was someone there that night from Paris,
well,
yes?
I would only say, and sometimes, circumstantial evidence could be as good as direct, if not better, as I could tell you, the plaintiff testified that it was him and his foreman and someone that was mopping and cleaning with a bucket from the bank. I mean, I don't know who else would go to the bank with a mop and a bucket and clean, and I'm just saying it is circumstantial. But again, this is the standard burdens of summary judgment, and they should have come forward in the first instance to rebut and address our allegation in the bill of particulars that you created and caused this. And it's not, they cannot step around the independent contractor rule, because there's two exceptions that are blatant on this record. As I said, the non-delegable duty, but more even importantly, is they had absolute control. It's replete, this master service agreement. I'd ask you to take a look not only at 702 and 706, but 718, and with respect to the area 20 feet outside that bank. So even if the municipality was responsible, and even if there was 4 snowstorms, that does not obviate and relieve Citibank's cleaner from taking care of the first 20 feet. And
it's Chase, but I think Citibank.
I'm sorry.
Probably
Any bank.
same thing. It's all the same thing.
Citibank's my bank.
Bank
so
of America.
I was thinking Citibank because that's my bank. But anyway, next to it, it does say it's nightly. So there's no question this was a nightly. Yeah. One last thing before I said, I would just ask that you take a look at the evidence showing that there is certainly a question of fact as to whether this falls under 23-1.7D in slippery condition. It's the only means of ingress and egress. He slipped. There's all the elements are there. Defendant didn't establish it wasn't applicable, and they didn't violate this. And there's a lot of cases from this court, most recently Potenzo and Lipinski that you know about, and Quigley, that all support denial of summary judgment on 1.7D. If you have no further questions, I'll rest on my brief. Thank you very much.
Thank you. Thank you all. MRE versus, MRE Technology versus Smith's Direction.
Good afternoon, Your Honors. May it please the Court, Paula Colbath from the firm of Loeb and Loeb LLP for Appellant MRE Technology Solutions LLC. I have just 3 quick points that I would like to note. The first is the court below focused heavily, and it was dispositive of her decision, on the date May 1st, 2018, as some hard deadline and a line in the sand for statute of limitations purposes and the breaches.
Wasn't that the date that you set forth in your complaint as to when the defendant began to breach the agreement?
So if you look at the record, the breaches continued through the end of 2019, and that's in the record at page 107.
That wasn't what I asked you. Wasn't that the date you put in your amended complaint as to when the defendant definitively began to breach the agreement?
No, the May 1st, 2018 date was when the defendant submitted a proposal to reduce 3 employees under the contract.
Counsel, hi. So in the complaint, you state that on May 1st, 2018, there was a material breach by SDI by implementing a 60-day rolling reduction, and then you name the employees of all MRE employees servicing SDI's call center. So the complaint characterizes the circumstances that happened on May 1st, 2018 as a material breach.
Correct. Your Honor, the nature of this contract is that my client supplied high-level, specialized trained staff at airports, prisons, border control, and they were all over the United States. So on May 1st, there was a request for one particular location, 3 employees, not having anything to do with all of the other locations under the contract.
But the relevant clause in the contract says that you have 2 years from the date that the cause of action first arises.
Correct.
So if there was a breach on May 1st, isn't that the date that the first?
No, here, because this contract is governed by New York law, and the trilogy of cases that are very recent from this court, starting with the matter of Yin Shing Loom Charitable Foundation at 177 AD 3rd, 463. You also have Manipal Education Americas at 203 AD 3rd, 662. That was 2022. And you have this court's recent Cobalt decision, where when a party to a contract has continuing obligations, then the continuing wrong doctrine applies.
Except that
here, this contract remains in force.
You contractually agreed to a different statute of limitations. You set the statute of limitations by contract as 2 years from the initial breach. So it seemed, why aren't you bound by that agreement that you made? Because our case law very clearly says that parties to a contract can agree on a different limitation of time.
And that we did agree to a 2-year statute of limitations or
from
provision,
the initial breach.
But that applies to each of the breaches.
Where does it say that in your contract? Your contract doesn't say each breach. It says from the initial breach.
And agreed, but so a lawsuit could have been filed on the 3, but that doesn't mean for the rest of the contract term they can do whatever they want under the contract.
The question is why not? The question is why not? If the parties negotiated this type of statutory limitation, right?
Because the breach you're talking about?
Counsel, please.
Yes.
Thank you. So this is the problem. We're looking at the words that you negotiated, the ones that you are bound by. And it simply says 2 years after the cause of action has first arisen, period. End of story. It doesn't, this is not a new cause of action. It's the same cause of action.
No, so the May 1st totally related to three distinct employees. Thereafter, there have been substantial breaches of very serious confidentiality provisions, and because they sent a proposal on May 1st relating to 3 employees doesn't mean for the rest of the term of the contract we're obligated to comply and they don't have to.
No, you could have treated the contract, and you should have treated the contract as breached. That's exactly what your remedy is. You're complaining that you negotiated a contract that says what it says, and the good thing for you is on that date, you don't have to perform anymore. You get to say, contract breach, I get damages. But you didn't do that. And the point is, the fact that you continue to suffer damages doesn't mean it's a continuing breach, particularly not when you yourself say the cause of action accrues on the day of the first breach of the contract, when the contract is first reached.
But obviously, this is a multifaceted contract, and there are a variety of ways that it can be breached. And the fact that
but you had the opportunity on that day to treat it as breached and not to perform thereunder anymore. Okay. That you didn't do that doesn't make it a continuing breach until you decide that you don't want to perform anymore.
No, we obviously have a...
And you do have time on rebuttal. Thank you.
Okay, thank you.
So, counsel, I'm just going to ask you, how do you respond to the continuing, because the contract says what it says, and clearly if it's May 1st is the breach, then it's out. How do you respond to the continuing wrong argument?
Yes, Your Honor, thank you, and Paul Arian on behalf of respondent. The continuing wrong doctrine simply doesn't apply to this agreement. The times in which this court and other courts have found it to apply are in circumstances where agreements have dates certain for future performance, have recurring duties, have obligations triggered by the occurrence of a particular event, like a pension disbursement on a date certain, like the payment of a royalty upon recognition of revenue or the playing of a record, whatever it is that triggered the payment of that royalty. There are no such continuing obligations under this agreement. There are no such recurring duties under this agreement. And therefore, as the lower court and as Your Honors have correctly identified, because the breach is alleged to have occurred first on May the 1st, 2018, the claims here, the breach of contract claim is simply untimely.
So I'm going to play devil's advocate.
Sure.
And the first set of employees, number 3, right? There were 3 people at the beginning on May 1st who your client allegedly poached contrary to contract. And then there were another set of employees who were poached. And then it continued until finally there was nobody left in that particular department. So why isn't each set of poaches a new breach?
Well, I think we can answer that by looking at the terms of the contract itself. The contract provides for the provision of services at particular levels and payment for those services set forth in a statement of work, and it also contains a provision that sets forth procedural requirements for changing those levels of service.
I'm
sorry, go ahead.
And just to throw something else into the mix, and your adversary also argues that in the papers that field services continue to be provided to SDI until December 14th, 2019, therefore that was a separate breach.
Right, and to answer that piece as well as the prior question, the distinction between the different types of services, the different buckets of services and personnel that were being provided under this agreement is completely immaterial. The statement of work establishes certain service levels and sets forth a procedure for those services to be reduced. The crux of the claim here is that the respondent reduced those services without following the procedural requirements in the agreement, and that occurred in May, and starting earlier than May 2018, but no later than May 1st, 2018. Once the services have been reduced beyond the levels set forth in the statement of work, the single solitary breach has occurred. Further, any continuing relationship between the parties, any further provision of services, any further reduction of services is outside the scope of the terms of the agreement. There is one single solitary purported breach here, and that occurred in May of 2018.
Thank you.
Thank you.
I just want to make one additional point, and that's that they cited no authority for the proposition that the continuing wrong doesn't apply in a case where the parties have agreed to shorten a statute of limitations. They have no case that supports that position.
The question isn't whether it shortens it, the question is what triggers it. And what it seems to me that your contract is very clear that what triggers the statute of limitations is the first incident of breach. So how do you distinguish?
So
are you saying that they breached it and then they did something else and that the 2 years starts over again every time?
That's exactly. Every time that there is
What
a
in the contract supports that?
distinct
What
wrong,
in the contract supports that?
the contract doesn't prohibit that at all. And it incorporates New York law, this is a well-established concept, and this court has addressed it 3 times in the last several years.
But not in contracts such as this.
The contract incorporates New York law, and the continuing wrong
But
doctrine is part of New York law.
those cases where we have spoken and addressed the continuing wrong docket, those cases are different. Those contracts are different than the contract that is presented here.
I don't think the fact that the parties agreed to a shorter statute of limitations.
No, but again, as my colleague said, that's not the issue. It's not that you contracted for a shorter statute of limitation. The issue is that your contract specifically states what triggers a breach. And you made the determination that the breach occurred on May 1, 2018.
And under the continuing wrong doctrine, there can be multiple points where the statute is triggered. And here, where the wrongful conduct falls into multiple buckets and happened over a series of events. This wasn't a decision where the defendant here came on May 1st, 2018 and said, we're terminating this contract. They requested to reduce 3 employees of 70, and that was not responded to or agreed to. Subsequently, there were additional breaches, separate, material, under the contract.
Right, and you just said there were additional breaches.
Correct.
So that constituted a breach on May 1, 2018. That's your breach. That's when your 2 years, it would seem, under the contract would run.
Well,
thank you very much. Have a good day.
Thank you.
Ma versus 40-44 West 120th Street.
Good afternoon, Your Honors. Anthony Prosher from Kaufman, Dolich, and Volokh LLP on behalf of defendant appellants Jeffrey Shupak and his law firm Shupak and Hardy LLP. As Your Honors are aware, plaintiff respondent hasn't appeared and is submitted. I just wanted to appear in case there was any questions. Otherwise, I rely on the arguments in my brief.
Thank you so much.
Thank you, Your Honors.
Take care. Angelo Gordon Real Estate versus Ben Lab Realty.
Good afternoon, Your Honors. May it please the Court, Anne Marie Bowler for appellants, the sellers in the underlying transaction. The lower court's decision should be reversed and the $12 million down payment be paid to the seller for the following reasons. 1, the purchaser's termination constitutes an anticipatory repudiation of the PSAs.
Counsel, your client never produced the estoppel certificate in the form that was required by the contract, right?
We would argue that the form we provided was, in all material respects, complied with the contract, but that is not the avenue of this inquiry.
Counsel, what was provided was radically different from what was required.
Even if
the tenant estoppel certificate specifically would have said that neither the tenant nor the owner landlord was in breach or in default under the lease. And what the seller provided was a certificate that said that the landlord only, wasn't in default under the lease. That's not what was required.
Even if that's true, Your Honor, that
Well, is there something in the record then that purports to be a tenant estoppel certificate?
there isn't, Your Honor, but that's not the line of this inquiry. This isn't the case of 15th and 5th as the lower court relied on. This is the case of MFP versus 933, which this court recently decided in November 2022. In 15th and 5th, the termination occurred at the closing. Here what happened was the day before the closing, the purchaser sent a letter terminating the agreement. It's an unequivocal termination of the contract. But under the contract—
On the ground that the landlord hadn't submitted the correct tenant estoppel certificate, correct?
That's correct.
And wasn't it true that under the contract, that was entirely appropriate? That was what they were allowed to do. If you don't give us this, we're allowed to terminate the contract, get our money back, correct?
Incorrect. They were not allowed—
Let me read the contract to you.
Can I direct you to—
Sure.
Paragraph, if you look at section 20, the last paragraph above paragraph H, it provides, if any of the foregoing conditions are not satisfied on the closing date, this was on the closing date, purchaser shall have the right to terminate.
Okay, did you send back a letter that said, oh, no, tomorrow we're going to do this?
No, because that would have been futile. They terminated the agreement. They had an obligation, in addition, to provide us a notice and opportunity to
That is your
cure.
argument, that the fact that it happened the day before the closing rather than the closing should change the result of this? Without any indication from you that you were ever going to submit the appropriate, and two, the fact is you couldn't, correct?
That's incorrect. That's incorrect.
I thought I saw in the record that there were tenant defaults.
They could have been cured. They were curable defaults.
Between the day of the day before the closing and the closing?
Sure, we could have cured the defaults, the monetary defaults.
So you're saying
Because
that the fact that there were two tenants in default, one at 489 Columbus and one at 491 Columbus, made no difference? Did you ever make a showing that made no difference?
We never get there. This is an anticipatory repudiation. Their termination is improper under the last paragraph of section 20, and also under section 9.1, subsection 18. At the closing, seller shall deliver tenant estoppels. The right to terminate on the basis of a condition precedent only comes about on the closing date. What they should have done was on the closing date. Also, time was of the essence as to them. So on the closing date, they were required to tender performance, hold us in default, and under 8.2, provide us a notice and opportunity to cure. They did none of that.
So they were supposed to wait until the next day when you did not deliver the estoppels and you were not prepared to go forward with the closing. They were supposed to wait for that to occur.
When a party anticipatory repudiates a contract, that terminates a contract before their time to perform comes about, the obligation on the other party is released. We're not obligated to perform. And as this court held in MF—
So if closing was at 3 o'clock, they had to wait until 3 o'clock on that day, like 2:59 or the day before. That's an anticipatory breach, according to your argument?
Yeah, well, they didn't do that.
It was the day before, right? Wasn't it the day before?
Right, and the time for performance was on the closing date.
Counsel, how do you deal with paragraph 20, subdivision F, which says, as a condition precedent, purchaser shall have received at least 2 business days prior to closing an estoppel certificate from each commercial tenant of the premises, et cetera?
Correct, that easily coincides with the right to cure provision. What happens here, as happens in many
That was not done 2 business days before, right?
we provided the estoppel certificates 2 days before. Instead of going back and forth
The seller estoppel certificates, not the tenant estoppel certificates.
That's correct.
Aren't we playing a shell game here?
No, the seller or tenant estoppel certificates were to be provided 2 days before. We provided them 2 days before, and what would normally happen is the parties can go back and forth and
Counsel, I'm reading this straight from a paragraph, subsection 20F. Purchaser shall have received at least 2 business days. I'm repeating what my colleague said. 2 business days prior to closing an estoppel certificate parentheses, collective the tenant estoppels, close parentheses, from each commercial tenant of the premises. So if the closing date was April 21st minus 2 is 19, and on the 20th, what was delivered were seller estoppels.
That's incorrect, Your Honor. The closing date was the 22nd. On April 20th, we delivered seller estoppels.
Yes, it was you're talking about the outside closing date.
Yes, that was the closing date. On April 21st, they terminated the agreement prior to their obligation to perform. This case is exactly like MFP, where an
So have you made a showing of good faith that but for this breach by the purchaser, this would have happened? Because in fact, here are the tenant estoppel certificates.
We never got there. The law is clear.
No, forget about that. Did you make a showing of good faith to show that you really did have them and you really were acting in good faith and you truly were ready, willing, and able to complete the purchase?
We did not, and we proceeded with the closing the next day, and they did not show up, nor did they provide us an opportunity to cure. 8.2 provides that for representations and warranties, they are required to provide us 30-day notice and opportunity to cure.
So that section talks about reps and warranties, right?
Right.
If you mess up a rep or warranty, then you have 30 days to cure it. That has nothing to do with your obligation to 2 business days before submit the correct estoppel certificates. You can't import that into this and the tenant estoppel certificates. And who would close under those circumstances? Who would close? If you said, maybe I might be able to cure that in 30 days, maybe not. That's just not the way, that's not the way that normally transactions go, right?
Well, in this transaction,
And that 30-day cure period has to do with the reps and warranties in Section 8. Doesn't say anything about, I can give you a non-conforming tenant estoppel certificate, which is 2 days before the closing, which is a condition precedent, and then say, when I say you haven't satisfied the condition precedent, I can cure within 30 days. That section doesn't apply to that. It applies to the reps and warranties in Section 8. Correct? Do you disagree
I
with
disagree, Your Honor. If
that?
you look,
think anything in the contract you had 30 days to cure?
the tenant estoppel is expressly a representation and warranty. If you look at the form estoppel for the seller estoppel.
And those were supposed to be presented at least two business days prior to the closing.
Which we
But we
did.
can discuss this on your rebuttal.
Thank you.
Your Honors, good afternoon. Stephen Meister for the respondent. Let's be clear here. The closing was set for April 22nd, which was a Wednesday. As Your Honors have discussed in Section 20F of the contract, it said that they had to deliver either the tenant estoppels or, failing the tenant estoppels, a seller estoppel if they wanted to hold my client to the contract 2 business days prior. There was no intervening weekend. It was Wednesday, so it became Monday. They delivered 5 seller estoppels on Monday. They were all non-conforming. Mr. Brusco, the principal of the seller, testified.
Well, I think your adversary stated they were substantially conforming.
But they were substantially non-conforming because not only did they excise the statement that the tenant was not in default, they included an affirmative statement that the tenant was in default. The whole purpose, the obvious purpose of delivering the estoppels 2 days before is so that the buyer can assess in that very short period before the closing whether the estoppels are conforming and then say they're conforming, I'm going to close, or they are non-conforming and I am relieved of my obligation to close. But
Counsel, what do you...
Your adversary states that that determination has to be made or related to them at the time of the closing, and that there's nothing in the contract which states that you can do so prior to the closing.
Section 20, it is a condition precedent to my client, the respondent's obligation to close, that conforming estoppels be delivered. But I think this point is addressed by the facts here, because although it was missing from appellant's presentation, what in fact happened is we got the estoppels, the non-conforming estoppels, on Monday, April 20th. On Monday, April 21st, with alacrity, we wrote back and said, look, these estoppels
Tuesday.
are not conforming.
Tuesday, April 21st, right?
I'm sorry. Yes, Your Honor. Tuesday, the next day, April 21st. On that same day, Tuesday, April 21st, they wrote back and they did not say, as they could have, well, we disagree with you, Mr. Meister, but we'd like the opportunity in 30 days or tomorrow or whenever to tender a conforming estoppel. Instead, they wrote back and said, you're wrong. The estoppels were conforming, and we reject, and it's null and void, your letter. And then on Wednesday, April 22nd, they terminated the contract.
So let me ask you, they never took the position with you that that 30-day cure period allowed them to adjourn the closing, right? Because that wouldn't have made sense with the time of the essence.
Exactly. And, Your Honor, you've really hit upon what really happened here is that this case was pled and litigated by the appellant based on a fundamental misapprehension of the contract. The appellant always believed, and if you look at their answer, they never talk about cure. What they say in their answer, I think it's record 78 or 79, is our estoppels were conforming because they believed incorrectly that the lack of a representation about the tenants being current in that Article 8 that you referenced, Justice Scarpula, meant that that overrode the estoppel requirement. So they never talked about cure, and they wrote a letter saying, our estoppels are perfectly good. We don't.
They never said, give us the 30 days to cure.
Right.
And in fact, would that have been inconsistent with the time of the essence?
Yes, it would have been inconsistent,
closing,
but
right?
also very important, the counsel said they could cure it. This is not a matter of them paying the money. The tenant has to be current. I don't know how they would cure it. They didn't.
Well, they said they could come up with the money, that they would be able to set the whatever.
You mean
the
what, to
were.
lend the tenant the money? The tenant, it's an estoppel. It's not a financial obligation of the seller. It's a statement that either the tenant is in compliance with the lease or not in compliance with the lease.
So
There's
what
no
you were
evidence.
bargaining for was not that they be up to date in their rent, but you were bargaining for a tenant who was in compliance, so you could expect that going forward, the tenant would continue to be.
Exactly. That, and this goes to financing, right? Because real estate buyers are always financing, and lenders want to know they have a tenant who's going to keep paying. So that's the essence of an estoppel. But
Well, I was going to ask whether this is something out of the ordinary that you would want a tenant to be up to date as opposed to, paying whatever outstanding or rent there is.
it's not out of the ordinary. What happens all the time is that the lawyer for the seller says, hey, I don't want to take on liability, and the buyer says, okay, then just give me an estoppel from the tenant, and we'll look to that. But there's no evidence in this record. Don't forget, this was the very beginning of COVID. There's no evidence that they put in that in the 30 days that they're now talking about, which is completely inconsistent with their pleading and their letters, that the tenants came current. So it couldn't have even been cured. There's no evidence in this record that, oh, the tenant paid and we could have delivered to you an estoppel, nor did they deliver an estoppel. So the cure argument just doesn't pass muster, and we were within our contractual rights. 15 and 5th is completely on all fours. It rejected the concept that that you can use the representations to override the estoppel. And the MPF or MFP case, there were no estoppels delivered. It was an issue of when the requirement arose, and the buyer purported to terminate the contract without any estoppels a day before they were due. And so the reason that this court affirmed the lower court's decision there in the seller's favor was because there was a premature termination. Here, We have completely different facts. We got the estoppels. They were no good. They were non-conforming. And we immediately said they're non-conforming. We're relieved of our obligation to close. And they wrote back and said, you're wrong. That's all, that you're wrong and we reject your letters.
Thank you.
Your Honors, this case is just like MFP, where this court found that a unilateral attempt to terminate the agreement before the deadline for the seller to deliver the tenant.
So in MFP, there was a 30-day, there was specifically, I get 30 more days to give you good tenant aside. It's literally said that specifically.
Right,
Not
just like
I have a right to cure, but I have 30 days to do that. That's not here.
Well, that's analogous to the right to cure here, but even if we didn't have a right to cure.
But didn't you take the position that your position wasn't that we can or we should be able to cure this? You said, no, these are conforming, correct?
Correct, because in the face of a termination, you are relieved of your obligation to perform. It was a termination before the delivery requirements were required. If you look at the express
At the time, did you say that?
we were ready, willing, and able to perform.
I'm saying, did you say we get 30 days to fix this?
It's not our obligation to do that. Cure
Did you ask for additional time?
It's not our obligation. Cure provisions are strictly construed. The language is this court found in 5 construction.
I'm not understanding. How can you say it's not your obligation? How would they know then that you are going to attempt to cure if you do not tell them that that is what you're attempting to do?
Their letter on the 21st should said, these are all the things you did wrong, and you have 30 days to cure.
But you're claiming that they said you had 30 days to cure as to the estoppel certificates?
Yes, the estoppel certificates are a representation and warranty. If you look at the estoppel certificate before number 1, it says landlord represents and warrants. It couldn't be clearer.
How could you have cured?
We could have cured by paying the money. This is in Schulman. The court found if an estoppel is, if monetary obligation can be cured, we could have paid.
But it wasn't a monetary obligation. That was the whole point.
Excuse me?
It was not a monetary obligation. That's the point.
No, they're holding that, they're finding that because tenants were in arrears, we were in default because the tenant
and would not be ready and able going forth to pay the rent. They were not asking for any payment of back rent by those tenants.
Yes, they were. There's no obligation in this contract that we're guaranteeing future payment. That's the real issue here.
But that's the point of the estoppel certificate, is that they wanted to know that the tenants at that time were current. They didn't want to know that you could pay off any debt the tenant owed to you. They wanted to know that the tenant was up to date because that provided them assurance, some assurance that the tenants would be up to date in the future. So I don't understand how you think that for you to zero balance your accounts would have accomplished the same thing as an estoppel certificate.
Because this is a seller estoppel certificate, and also we're not guaranteeing future performance. There's nowhere in the contract that we're saying that Shake Shack or any other tenant is going to perform in the future. That's what they were scared of. This was April 2020.
Right, but if a tenant has been in arrears for 24 months, why now, if I'm the buyer, would I want to take on that responsibility, knowing that they probably are going to be in arrears in the future? That's the whole point of the estoppel certificate.
Well, if you look at the language in the contract, we never guaranteed that nobody was going to be in arrears. There's no provision in the contract.
But they would make that determination by letting them know what the situation is. They can then make a informed determination as to whether they want to proceed or not, or how they're going to proceed. But anyhow, thank you very much.
Thank you, Your Honor.
Gemsco Realty versus N47 Associates.
Gosh.
Who's this? EG, yes.
What? I know. Got that.
You got that?
There must be something karmic that I did.
Ready?
Yes, Your Honor.
Proceed.
Good afternoon. My name is Pia Reverso, and I am here representing the appellant and cross-respondent N47 Associates. We are here today over a dispute involving, at most, small and large end, and at its widest, an 18-inch strip of property in Midtown Manhattan by Rockefeller Center for the sole reason that Gemsco can avoid closing its illegal lot line windows.
Counsel, I have a question.
Sure.
Gemsco states in its brief that you don't dispute that Gemsco's predecessor constructed walls and a roof over the strip. Do you agree with that?
No.
Or if not, where do you dispute it?
What we do is Gemsco's statement is based on the DOB amendment. And what the DOB amendment said is that Gemsco was asking permission from the DOB to construct the closure of the gap that it created when the predecessor demolished the party wall with the prior owner of N47's permission.
So is there a point in the record where you specifically dispute that Gemsco's predecessor constructed walls and a roof over the strip?
Well, we do dispute that, in fact, it's not a roof. It's metal grates. It's not an enclosure.
And where do you dispute that?
Well, we dispute it specifically, Your Honor, in the record when we show the picture. If you look at paragraph 9, I'm sorry, Your Honor, picture 98, it shows that it's not a roof, is what I'm saying. Not that who put it there, but it's not a roof. It is a metal grate where rain can fall right through it. And if you look at picture 98, that's a picture taken from N47's roof, looking at the opening.
So, I
that is
mean,
the gap.
isn't that basically something that we should get expert testimony on from either and both sides as to what that it actually is?
We have.
I mean, I look at a picture. I don't know what it is. It's like a black and white picture that I don't see very well.
Well, the pictures in the
You
record.
weren't able to put your experts' testimony in, correct?
Yes, we were. That's exactly it. We did put in the expert testimony.
But it was the court didn't accept it, right?
No, the court did accept it on the motion to renew.
Which did you put on the surreply?
Yeah, well, it wasn't a surreply. What happened in here was Gemsco moved for summary judgment. They did not raise anything about their obligation to comply to 522 or 543. They didn't even mention that part of the RPAPL. When we opposed and we cross-moved, we made reference to the fact that they did not sustain their burden and we own the property and you need to comply with these sections. In their opposition to our cross-motion and reply, for the very first time, their surveyor, who really is not, raises reply and raises that the walls are structural. Now they're trying to comply. We asked the court for permission to respond to all their arguments. The court granted us that permission in the record at 329. So in response to Gemsco's newly raised argument.
No, but you have, so we have two different people saying two different things, right? One saying yes, one saying no.
But it's not a battle of the expert because as the cases that we cited, the Matak case and the Amaya case, the court has absolute discretion to make a decision as to which expert is believable.
Well, okay, or we could leave it to the jury, right?
But you're dealing with, but you have to understand the nature of this case, which is you're dealing with a surveyor who's also an attorney who makes a statement that these walls are possibly structural. That has no credence.
Well, the jury would determine credibility, right?
Excuse me?
The jury is going to determine credibility and who they would believe.
But on a motion for summary judgment, the case law says that the judge is able to do that, especially when you have an expert who has absolutely no expertise in the area that he's testifying to.
So
that would be like an ice cream maker saying that wall is structural.
Excuse me, which of Gemsco's experts do you claim were entitled to no weight?
Excuse me, I'm sorry.
Which of the experts proffered by Gemsco are you claiming were entitled to no validity?
Both of them. One was a surveyor. You have to look at what they put their testimony in. One was a surveyor who's also an attorney, and he said these walls are possibly structural. N47 wanted to debunk that immediately and put in the affidavit of the person, the individual, a licensed civil engineer in the state of New York, who was the design applicant for N47, designing the demolition on site, making the observations. And then you have Mr. Nevins, who's not even a licensed architect, not a licensed engineer, who made the opinion that there was possibly maybe some other things that were on that wall, but he really didn't know. And the reason why the court rejected his opinion and made a finding that it was completely speculative is because he had absolutely no familiarity with the local site conditions. He said his opinion was based on pictures from the pre-con survey. We gave the court those pictures from the pre-con survey. They had nothing to do with the wall that is at issue.
So, counsel, can I turn to the left and ask you a question? What is your client's view of whether or not you need to have direct evidence in order to support a tacking claim that the prior owner intended to convey the adverse property, or can you establish it by circumstantially?
Well, the decisions that have come out all say, and the ones that are cited by N47, Bellotti, Brand, all of them, I call them the B cases, there was all evidence that there was a witness who heard that this property was there.
Right, but
There was an owner who
is that a standard of law? You're saying that that's required,
You
that
need
you
a
must
witness,
have
and you're
it?
talking about from 1946?
Right, how could anyone?
We're going to get a witness now from 1946 who's going to testify that that was?
No. What we're talking about is when Gemsco purchased the property.
So that was 2007, right? That was 2007, right?
Yes, Gemsco needs to establish in 2007, when it purchased the property, that the prior owner of the property intended to actually transfer this section. The reason why Gemsco can't do that, it doesn't even offer who the prior owner of the property is. Gemsco simply says, I looked at it and I thought it was mine. But Gemsco doesn't even know its own property.
So, I mean, why isn't that enough? That, you know, I look, when I went around with my broker, that was, I looked at that, no one said it wasn't mine, I assumed it wasn't mine. Why doesn't that raise an issue of fact?
That is the whole, I'm sorry, that is the whole point of the 2008 amendments. You have to have a reasonable basis for your belief. The courts do not say that a reasonable basis for a belief is, oh, I looked at it and it looked like it's mine, especially in light of a survey that shows you that it's not. And that's not an N47 survey. That's a survey that was done for Gemsco. And if you look at that survey, it actually shows there's no exclusivity. That's the biggest point here. We did raise exclusivity. We raised it at page 146. We raised it again.
So let me interrupt you for 1 minute. So you're saying at a minimum that Gemsco had to submit something from the prior owner, not just its own subjective belief, but something from the prior owner from which a letter, a note, you get this whole thing, something.
Something about a conversation.
Right, okay.
That's what all those
cases. It can't just be your own subjective.
Well, not only you get this whole thing, but that I own it, and therefore I can transfer it to you.
Exactly. Because if you look at the reason why that gap was enclosed, if you look at the history, and that's why the affidavits of the engineers are so important. Con Ed had its building there. There was a party wall at one time that the prior buildings share. Con Ed decided to demolish its building and build a new building, but it left the party wall because the old prior N29 building was there. So it builds a building on the outside of the party wall. So then what happens? The prior owner of the Gemsco property comes in and says, okay, I want to build a building, but I need to demolish the party wall to do that. So they go to DOB, they get my permission, the predecessor owner permission, to demolish that party wall. But now that they've demolished the party wall, there's a gap. So they build their 16-story building, and they create a gap for those first 6 stories. And that is the answer to all of the mystery that, oh, there must have been a foundation wall that you destroyed. There had to be these other pilasters that you destroyed. It's nonsensical. How could there be other pilasters that you destroyed based on the conclusion?
Counsel, then what do you say about the third department case, Strom versus Placus? So that seems to suggest that you can infer that the prior owner intended to transfer the property without direct evidence from something from the prior owner.
As I recall, was that not a case where there was a building? In that case, there was an actual building, like not a little tiny wall. There was a building on the property. So when you have a building on a property, that is something different, because when you intend to transfer the property, you can't transfer, half of the storefront. You're intending to transfer the building. That's not the case here. And the DOB document, which the court should have considered, and which ironically Gemsco relies on heavily, although its interpretation is wrong, that DOB document gives the story. It says, okay, we want to now demolish your party wall. Okay, we give you permission to do it. But like anything else in New York, you have to close the gap. And if closing the gap gives the person who's obligated to do that title to that property, it creates a real dangerous precedent. Your Honors, I do license agreements all day long. I know the court is familiar with 881. It's an obligation of a contractor to install flashing and an M seal when it constructs a building. Well, does it now have a claim of ownership to that property because it's doing what the DOB tells you to do in order to protect a condition created by the building of your new property?
So you have time on me, bottom.
Yeah, okay.
May it please the court, Andrew Lawley of Armstrong Teasdale LLP on behalf of Gemsco Realty. I think your honors have sort of hit the nail on the head here. And I want to start by putting this into context. We are talking about 150 square feet of real property, not located on 10,000.
You know what's at issue, counsel?
Okay, yeah, my point is it matters here. People notice that amount of space in Manhattan, in Rockefeller Center. And these are not phantom constructions. There is a building on the property. If your honors are to look at the record on page 214, if you turn that image 90 degrees counterclockwise, it is a brick wall that extends 6 stories up into the air. You can see rubble on the ground, and it is sealing off space. That's on the north side of the property. If you look on the south side of the property, onto page, and you can see this, it's a post-demolition photograph, unfortunately. We can talk about spoliation.
I have a question.
Yeah.
You rely a lot on the 1946 survey, correct?
Yes, we do, Your Honor.
But what puzzles me about that is that the 1946 survey includes a comment that it was impossible to verify that the foundation wall of the Gemsco building encroached 9 inches over the property line. So why does the 1946 survey help you?
Right, well, so in 2 ways, Your Honor, and those are 2 different, actually, theories of adverse possession here.
Well, but with regard to the foundation wall, isn't that a problem for you?
No, I don't think so, because with respect to the best evidence rule, the 1930 survey at this juncture doesn't appear to be extant, and surveyors regularly rely on prior surveys.
Right, but what it says is that we can't verify it, so how does that establish that the 1930 survey said something else?
Well,
it doesn't how does the 1946 survey affirmatively establish what was in the 1930 survey, since all that they say is it's impossible to verify?
Because the surveyor is entitled to rely on the predecessor's work. That's the point.
But what in the 1946 survey indicates that that surveyor relied on what was in the 1930 survey to establish that the foundation wall of your building encroached 9 inches over the property line?
Well, Your Honor, he's making reference to the 1930 survey. And he says it's impossible to verify the 1930 survey because I can't physically get inside, right? So he must be looking at the 1930 survey if he can't verify something in the 1930 survey. So
I have to tell you, there are so many questions here that make me think that they can only be resolved by a trial. Well, there's question upon question upon question.
I understand your point, Your Honor, but think about that 1946 survey again for a minute, right? Because that actually supports that there is a substantial enclosure. Why can the surveyor not verify whether or not the 1930 survey is accurate? Because there's a
But that's
substantial
still
enclosure, you can't get
But
inside.
even so, counsel, that still doesn't get you, that doesn't get you through tacking, right?
Well, I think it does, Your Honor. I think
How?
it does. Because this.
What have you put in to show that the prior owner intended to give you that piece of property that you don't own?
Well, I think Your Honor hit the nail on the head earlier, as I said. I don't think that we have to show anything. The law of adverse possession is such that things occur.
Not for a tacking claim, you don't have to show anything, you're
The law
allowed?
presumes you're buying the entire building, Your Honor.
But the entire building is the building that you
In the
bought at
survey.
49 West.
That doesn't include that, I'm sorry, right? It doesn't include your property.
I have to disagree, Your Honor. These walls are built into our property.
No, they're non-retaining wall. It's a non-retaining wall. And how do you respond in terms of post-2008 RPAPL that the existence of de minimum non-structural encroachments, including blah, 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 and non-structural walls are deemed to be permissive and non-adverse? And you have a non-structural wall, correct?
Well, that I disagree with entirely, Your Honor.
Oh, you're saying it is? Who's
Structural?
absolutely.
Where in the record does it state that it's structural? Who is saying-
A structural wall, Your Honor, does not have to be load-bearing, which is effectively, N47 respectfully, in their reply brief says we're not asserting that it must be load-bearing, but they also say that it has to provide support. And frankly,
did you put in any evidence in the record to show that because literally it says a non-structural wall. So what is it that you put in to show that this is a structural wall?
it's a structural wall, Your Honor, because it's there to protect.
No, where in the record is there, what did you put into the record showing that it's a structural?
Certainly, Your Honor. If you look at pages, compare pages 469 and 471 in the record, you will see that the original 6 stories there, those are terracotta bricks, right? Those are susceptible to, I understand, Your Honor.
Yes, I want to just, again, sure, I can look at 1,000 pictures. I'm not an architect. I don't know what's structural. What did you put in to show that this is structural rather than non-structural?
A structural wall, Your Honor, is something that provides a function for the building.
Again,
this protects the building.
Did you put in any factual or expert testimony that would lead someone who isn't a surveyor, who isn't an engineer, to say, oh, I can rely on that, except for oral argument by counsel, that this is a structural wall?
Your Honor, I think, yes, our architect, he believes that this is a structural wall. He puts in evidence.
What did he put in?
Well, he disagrees fundamentally with what the architect.
Can you tell me? Yeah, because I didn't see it, and I'd like to. What are you talking about?
Are you talking about Mr. Nevins,
Yes, Your Honor. I don't think I have that in front of me.
who was not in fact an architect?
Well, he graduated from Pratt Institute and has a bachelor's degree in architecture. He is not
Right, so
a
he's not an
licensed
architect.
But, Your Honor, he has over 30 years of experience in the field of construction. He plainly has all kinds of
But he's
experience.
not an architect.
He is not a licensed architect, Your Honor. That's correct.
Counsel, I have a separate question, if you don't mind.
Sure.
Do you agree that there's no evidence in the record that shows that the entity from which your client bought the property made a representation to your client that the strip was part of what they were purchasing?
I would agree there is no evidence in the record to support either party on that issue.
Thank you.
Thank you, Your Honor.
Thank you.
That was the smoke and mirrors question. In case you're wondering.
I do want to address.
I think Justice Scarpula had a question for you before.
I wanted to ask you about post-2008.
Yes.
Okay, so is your reading of the statute that if it's a non-structural wall, as a matter of law, you cannot, it's de minimis and can't count? Or
yes,
are there some non-structural walls that can count as not de minimis? Or that's what my question to you is.
Your Honor, I think it's, if you look at the history and you go back when you're reading all these cases, you'll see the whole point of 522 and 543 was such that the legislature wanted to eliminate these type of bad faith claims, and they made it very clear. If it's non-structural.
Even if it's literally load-bearing and everything else, if it's just if someone,
well, because that's,
someone
I
testifies
disagree.
that it's non-structural, that's it, you're out, you're done, it's over?
Yeah,
Okay.
because that's what the courts That is what the legislature did by amending that. If you read the history of it and you read where they were trying to go with all these amendments.
So then what do you say about Wright versus Sokoloff, 110 AD 3rd, 989, which I think the Second Department didn't agree with that view?
Well, it's, you know, Wright versus Sokoloff, the language there, and I'll say that.
I agree, it's not the clearest, but
It's
to
not,
me.
that's the whole point, it's not the clearest. So you have a hedge, but a hedge is not a non-structural wall. I would be more looking at Sawyer, at the decision in Sawyer, where they were dealing with a non-structural wall that was even substantial. That's the way the court described it in there. They're looking at a non-structural wall that was substantial. So the decision in Sawyer was far more appropriate, more analogous than the Wright decision, because I don't really think the language in Wright was clear. But I did want to address one of the judge's comments about thinking that there were so many questions of fact. It may appear that, and that was the goal of GEMSCO, to defeat this so they can further delay this construction. There are no questions of fact. The judge was very correct. Justice Edmead was correct in what she found, and the only area where she was not correct is where she did not award summary judgment to N47 on 3 very brief issues. And I know my time is up, but I've answered a lot of questions. I'd like just to get these 3 issues out.
Just tell us the 3 issues.
The 3 issues, Your Honors, were the exclusivity, and we've pointed out in our brief where we did raise it. It was, they had to come onto our roof to get access. How could it possibly? The other 2, Your Honor, was the structural. We addressed that briefly with Justice Scarpullo. And the last issue was the corbel, and I just want 30 seconds to address that.
30 seconds.
The corbel was not the retaining wall, or not the retaining wall. That wall was not 6 stories high. I urge the court to look at the survey. In the upper corner of the survey, it has it written 1-story brick filler, and then if you go south, it has another brick filler. There was 1-story brick filler that was there at the very end of the property. We took that down. It wasn't structural. Nothing happened.
Thank you.
Thank you, Your Honors.
People versus Angelo Rodriguez.
May it please the court, Alma Gonzalez for Mr. Rodriguez. The court should reduce Mr. Rodriguez's sentence or vacate and dismiss. The resentencing in this case did not fully remedy the harm that was caused by the error at the original sentencing proceeding. And that's because had Mr. Rodriguez's original sentence, even of the 5 and 5, been reinstated at the resentencing, it still would not have remedied the fact that he was kicked out of the shock program, sorry, Your Honors, because of the fact that he was wrongly sentenced as a predicate in this case. Had he been correctly sentenced at the beginning, he would have had the opportunity to complete that shock program, which would have resulted in his immediate release, and which would have meant that he would have completed his sentence back in November of 2022.
So you're seeking a reduction to 3.5, right? Well,
Yes, Your Honor.
He already, what am I saying? He was already released.
He finished his sentence.
Right.
No, he has not.
He's on post-release.
He's on PR, yeah.
Well, when someone's released, their prison term is held in abeyance until they finish completing their
right, but
PRS term.
He's on a PRS right now, right?
Right, he's on post-release. So I'm not understanding what you're requesting now. 3.5 with how much post-release supervision?
Sorry, Your Honors, he was also sentenced to 4 years of post-release supervision, and the minimum is 2.5.
So you want you want to resentence, or you want to resentence to 3.5 years incarceration with 2.5 years post-release supervision?
Correct, which is the minimum, yes. And
so he was sentenced to 4 years post-release supervision, right?
Yes.
He was resentenced to 4 and 4. So he's released now, so he finishes his post-release supervision in 2025?
Well, that would be the max, but under less is more, his.
That was going to be my next question.
Yes.
So under the less is more, he would probably, this is 2023 now, right?
Yes.
So he's probably going to finish either this year or next year, or probably this year.
According to his docs page, it would be November of this year.
November 2023.
Correct.
And we are in April 2023.
Yes, Your Honor, but that doesn't remedy the original harm, which is.
And what was the original harm? Because of the predicate felony?
Yes, because of that incorrect status, docs took him out of the shock program, which after the 6 months of that program, had he completed it successfully, he would have been eligible for immediate release and started serving his PRS
He did
term.
get a reduction.
He did, Your Honor, but.
I mean, he did do things that definitely showed remorse and rehabilitation, and it appears, and I mean, I was impressed, and it appears that the judge took a real hard look and was also impressed, because the judge said, "Oh, I was going to resentence at the same way, 5 and 5, but now I've looked at everything and I'm going to do something different. I'm going to do 4 and 4." So, but you're saying that's not good enough.
Well, because, Your Honor, even had Judge Ward resentenced him to the same 5 and 5, had the status been
No,
correct,
wasn't he resentenced to 4 and 4?
He was, but I'm saying even if he hadn't been, he actually would have been completely done serving his sentence back in November of 2022, and he's still continuing to serve this time because of that original incorrect predicate determination.
I'm sorry, I didn't understand that. Could you repeat that?
Yes, Your Honor. So had he correctly been sentenced as a first felony offender back at the original sentence, even with the original 5 and 5 term, he would have been able to complete the shock program, which is a 6-month program. Once he finishes serving that program, he's immediately eligible for release.
Was he actually admitted into shock and then Doc stated that he wasn't eligible?
Correct, yeah. He served 2 months of that program, and then Doc said, "Oh, wait, no, we made a mistake. You're actually a predicate offender, and so we have to take you out of that program because it makes him ineligible." And so that's kind of the disparity here. He's currently set to finish serving a term in November of this year when he could have been done back in November of 2022. And meanwhile, Judge Ward didn't take into account the fact that his co-defendant received a sentence 2 times lower than Mr. Rodriguez.
Yeah, but there was a difference between his actions and the actions of the co-defendant. But you have time on rebuttal.
Okay, thank you, Your Honors.
Good afternoon, Your Honors, and may it please the Court, Jennifer Mitchell for the people. Defendant's conviction should be affirmed. To begin, both of his statutory speedy trial and excessive sentence claims are barred by his valid appeal waiver. Turning first to his speedy trial claim, defendant forfeited his right to raise that claim by pleading guilty in this case. Defendant's plea occurred before CPL 3036 went into effect, and as this Court has repeatedly held, that statute does not apply retroactively. Even if you found that the statute did apply retroactively, only 155 days of speedy trial time were properly charged to the people. The people's 2 statements of readiness were not illusory, and the May 30th, 2018 statement was independently valid. Because they were in a period of post-readiness, the people were properly charged with only the time that they had requested and were well within the speedy trial time allotted. And with regard to defendant's excessive sentence claim, defendant's lenient sentence should not be disturbed on appeal because all of the purported mitigating factors that he cites have already been fully considered by the resentencing judge below.
So, counsel, given the fact that there was an issue with the original sentence because the New Jersey conviction really did not constitute a felony here in New York, and he had to be resentenced after he had been in the shock program and then excluded from the shock program, and he had already, I guess, served almost 2 years prior to resentencing. Why not resentence him now to 3.5 with 2.5 post-release supervision?
Your Honor, There's no need to resentence him at this point. As the panel has already discussed, he's set to be released from post-release supervision this year in November, which is just a few months away. The resentencing judge below already lowered his sentence because he has shown remorse and accepted responsibility for his actions. And while that's obviously commendable, it's already been taken into account in this lowered sentence. And so for these reasons, those factors have already been fully considered, and there's no reason to reduce further at this point. If there are no further questions, then the people ask that you affirm. Thank you.
Thank you.
Your Honors, this is not just a few months for Mr. Rodriguez. As the Court of Appeals laid out in People v. K2, PRS, post-release supervision, is not a small feat. It's still restrictive on one's liberty, and for Mr. Rodriguez in particular, it really has hampered his ability to retain employment in particular. And so just a few months does not, first of all, really diminishes the impact that it's had on Mr. Rodriguez, but also it still does not address, again, the initial harm, which is he should have been done months ago, serving his sentence. You know, his co-defendant was done completely serving his sentence back in 2021, and Mr. Rodriguez is still here, despite doing everything that has been asked of him and more. So for those reasons, we do ask that Your Honors reduce. Thank you.
Thank you both. Parker v. Parker.
Good afternoon. May it please the court. My name is Michael Bavacqua from the law firm of Mandelbaum Barrett, and I represent the plaintiff appellant respondent, Ula Parker, on this appeal. This is something a little different than what we've been hearing all day long. This is the appeal of the lower court's order, affirming in part and disaffirming in part the judicial hearing officer's recommendations and report after a 14-day trial on financial issues. There are several issues that Mrs. Parker, the appellant, is appealing. The submissions were massive. I'm certain that you have read everything. I'd prefer to spend my time answering your questions if you have them. Otherwise, I'll start with the points that I'd like to reiterate.
I have a question. The JHO estimated that with the equitable distribution that she recommended that your client would leave the marriage with about $38 million in assets. Do you agree with that? And is that how you calculate it?
No, Your Honor. The calculation of assets, which was just provided post-trial, by way of post-trial submission, listed the primary asset, which is the New York City apartment, which, if sold, is going to be subject to real estate commissions, capital gains taxes, and also failed to appreciate that Ms. Parker would have to purchase a
Did you put in any evidence about the tax impact of any of the, did you tax impact any of the assets in terms of the evidence that you introduced before the JHO?
We discussed the fact that...
I'm asking what you discussed. Did you put in any evidence of the tax impacting of the value of any of the assets?
No.
So how could the JHO consider that?
Well, based on the purchase price of the house and the estimated increase in the value.
Without any evidence?
Well, there would be capital gains, as you could take just judicial notice of it. They purchased the home for $16 million in 2004.
But you didn't produce any evidence as to how that capital gains calculation would be done under these circumstances, right?
No. No, we didn't. Ms. Parker.
But back to my question, what is your estimate, putting aside tax impacting, of what your client will receive in equitable distribution in terms of value?
It all depends on what the house sells for, the residence sells for. The accounts have been significantly dissipated at this point in time. The hedge funds are really not
You have no
liquid.
idea what the house is likely to sell for?
I'm sorry, Your Honor, I didn't
You
hear
have
you.
no idea of a sales price at this point? A range?
Maybe $45 million?
And you have a $9 million mortgage, right?
Yeah, it's about $8 million, correct, at this point in time. And there would be real estate commissions and gains, since $45 million, they only bought it for $16 million way back when. And the lower court also ignored the fact that Ms. Parker, if the apartment is sold, she's going to have to find a replacement residence that's reasonably comparable with the marital lifestyle, which was extraordinarily opulent. She's going to have to purchase that. It's going to be a significant amount of money in order to provide replacement housing for both her and the party sons, who, while they're both in school, home base is with mom. So that's going to, dig very deeply into the amount of money that she's going to have available to keep invested, earn investment income, and live on after taxes. In addition, with regard to the hedge funds that Ms.
Are you
Parker
arguing, I'm sorry, are you arguing for spousal support for the wife?
Yes. Yes, we are arguing for spousal support for the wife, based on the things that I was just mentioning, the fact that she's not going to have a huge pool of assets, the income from which is going to support a reasonably comparable lifestyle.
But she's highly educated, and she has serious investment skills, right?
Your Honor, she
And
hasn't.
she's going to have dollars to invest.
She will have some dollars to invest, but it's not going to be enough where the income off of equitable distribution is going to be enough to support the lifestyle. She hasn't worked since 1998, and she was, educated and trained in the areas of artificial intelligence. The lower court found that she's not expected to get a job. She never worked, and there was
I thought she had a degree in theoretical math and computer science from Cornell.
Yes, and she's never worked since 1998, Your Honor. And the lower court found that under the circumstances, she's not expected to go back.
But she was requesting $200,000 per month?
$100,000, Your Honor. That was.
You lowered it from 250,000.
She initially wanted $200,000, and she lowered it to $100,000.
Yes, that's what was initially requested. It was lowered. My time's up. So
you have time on rebuttal.
I didn't hear you, Your Honor. I'm sorry.
I said you have time on rebuttal.
Yes.
Good afternoon, Your Honors, and may it please the court. Charles Fox, Miller, Boy, Schiller, and Flexner on behalf of the husband. For 8 years, this case has been pending, 8 years for a divorce. During that time, the JHO and the Supreme Court have repeatedly described the wife's positions taken on every issue of this divorce as at least the following, quote, unprovable, confused, exaggerated.
Counsel, do
Not
you have an estimate of what she would receive in equitable distribution if we were to affirm?
Yes, so there are some variables, as Your Honor can imagine, but
I understand the house is for
yes,
sale.
I agree with his assessment of the value of the apartment at about $45 million. Now, since the time of the final judgment, I have no idea what the wife really has done with all of her money. So she had access and unilateral control of all of the parties' liquid assets. I don't know where they are, and I'm not exactly sure how much they're worth. We've had some recent discovery to prepare for another child support hearing. But the fact is that at the time of the final judgment, the estimate was that she was going to receive between $25 and $40 million. And that estimate was based upon not just the value of the apartment and the hedge funds, but it was also based upon the fact that they own a great deal of personal property and jewelry. But I'm not just talking about used couches like we see in these divorces that are worthless when you go to sell them. They own like pieces that have been sold at auction for hundreds of thousands or millions of dollars. That is the reason why in our cross appeal we moved for a receiver, because the wife took them. She hired somebody, loaded them up, and removed them from first their country house in Southampton, and then she's been in unilateral control of their assets and their wine collection in New York. We don't know where they are. We don't know what they're. The JHO ordered everyone to do a list of what they had. Our client did. He was cross-examined on it for like a day and a half. The wife won't do it. We don't know where it is. We don't know how much it's worth. We don't know whether she sold it already. So when I say she was going to get between 25 and 40, she's either going to get it or she's already gotten it. I really don't know. Here's the problem. We can't get my client divorced. The court has already found her positions to be frivolous. You pointed out the alimony. She asked for $200,000. If they've lowered it to $100,000, it was after the trial, because up until the end, I was defending, cross-examining the wife on $200,000. My client only makes $600,000 to $700,000 a year. And that's him scrambling around, trying to maintain 4 businesses, serving on boards to make ends meet. So the JHO.
So, counsel, how do you respond to the allegation that your client dissipated the assets during the marriage by investing in essentially loser investments?
So my client is.
I mean, of 8, I think 6 of them have no value, right?
Yeah, so, well, 2 of them had no value long before the trial, right? And they were long dead. The other 4, he's still working. I mean, Your Honor, he still believes in those enterprises, and he's trying to make them work. One of them, Nick, it requires the cooperation of the state of New York and the city of New York, and that has led to a lot of problems. It's been in litigation. But he still believes in them, and he's still trying to make them work. The problem was...
Is that Next Jump and the wines, or are those other?
I know. So Next Jump is an investment that they made and that he worked. He was on the board, and it was one of his former proteges who started the company. And he went to work for that company.
And then there's one with his brother, right?
He has one with his brother, Kevin, George Parker. He has these, but the 4 that were active at the time of the trial were Next Jump, which was controlled by somebody else, but he was on the board and worked there. They were his hedge fund, which is SICM, which it takes 5 years to establish a track record. So at the time of the trial, it was not profitable. It had never made any money. Then he had the ice skating rink, which he was developing the old armory. And of course, that required $140 million of funding from the state, and there were all sorts of holdups and lawsuits with respect to that. And then they owned a vineyard in France that they had bought when they were much, much richer. And it lost money for 17 consecutive years, which is why when we appeared at trial, it was only worth its net book value. So we had it appraised by a French company.
How do you lose money in a vineyard in France?
Yeah, so
I'm
tell you.
just wondering how that is possible.
They were one of the first vineyards to ever be biodynamic. That is, they were organic. And they got crushed. You know, the bugs ate it. And there were all sorts of problems, and they couldn't make money at it. Now, all of those things, okay, there was no question about it. The only reason why the French appraisers didn't testify in court and the report became worthless is because Mrs. Parker wouldn't pay them. In fact, Mrs. Parker wouldn't pay anybody. My client got eviction notices because she wouldn't pay his rent. She wouldn't pay CBiz, which is their accounting firm. Is
the apartment up for sale now?
She won't list it for sale, so she's been ordered to sell it. But the final judgment cannot be entered until we finish the child support trial, which they're making us finish. Their position on that, by the way, is that the child support guidelines don't apply to it. So that's going to be another disaster. But we have to finish the child support trial before we can get a final judgment. And
but
unfortunately, the lower court ruled that the apartment doesn't have to be sold until the final judgment is entered. Now, we've brought that before Your Honors twice at the risk of incurring your ire. Both times our efforts were denied. But she's in arrears. And it's their largest asset, and it's the thing that will help them move forward. So we are concerned, and that is the reason why we brought those claims.
Thank you.
Thank you. I appreciate it. It was a great day, by the way.
We had fun.
I'll try to be quick. What happened to a lot of the money is that it was used to pay living expenses. There was no Pendene Lite maintenance.
So when did the husband's salary go from millions to like $500,000 or $600,000?
Like in every other case, the year that the complaint for divorce was filed.
Oh, I thought it was, yeah, like 2008.
No, every year that the parties were married, the husband
I
made.
mean, that's not what the JHO found, right? Are you saying that that was, what are you basing that on?
No, the JHO didn't find that he had stopped earning long ago.
No, not stopped earning, but clearly at the beginning of their marriage, when they bought the 16-bedroom apartment, whatever it is, he was making millions, and then by 2008, he was making less than $1 million. Is that, that seems to me a factual finding by the JHO, which was adopted by the court. Are you saying that wasn't the case?
That is 100% not the case.
And what do you have to show that that's not true?
Well, Mr. Parker was employed by Deutsche Bank until 2012. In 2013, with his deferred compensation, he had $7.7 million in income just from Deutsche Bank. In 2014, which was the last full year the parties were married, Mr. Parker received $12.6 million in deferred compensation from Deutsche Bank, plus sold art at a profit of $6 million, so had almost $20 million in income.
Which of that was earned income?
Excuse me?
What part of that was earned income?
The deferred compensation of $12.6 million.
That's
not earned income.
Well, it's deferred compensation from when he was working.
What was the earned?
No, he wasn't working at the time, except he was trying to get SICM started. But what's clear from the record is that when he left Deutsche Bank, there were no immediate concerns for money because he knew he had these significant sums of money coming in. So every year that the parties were married up until 2015, he had tens of millions of dollars coming in to live off of. And he had been earning millions and millions of dollars since the time he was 32 years old in 1991. He was earning $6.5 million. In 23 years since then, he earned millions and millions and millions and millions of dollars up to the point where he was earning $25 to $30 million until the year that the complaint was filed. And then he decided that he wanted to follow his dream of being an entrepreneur, and he even refused to engage in discussions with Deutsche Bank in 2015 regarding a return to employment. It never even got to the point where he learned what his position would be, what his compensation would be.
Thank you. Thank you both.
Thank you. Did you come up from Florida?
Yeah. There was nobody else to come today, so it's okay.
Who else?
I was sworn to the bar here 30 some odd years ago anyway, so I kind of like come here. But
yeah, I haven't been here in a bunch of years in person since before COVID.
Right. And that's the same. I was here